That's all right. We were waiting
And
on it.
who signed it?
Yeah,
It's a long way across, Dan.
Well, I think I had every, well, there's lots of construction.
Who said? She did.
Bylaws is one thing on the agenda. Well, they kept getting ripped up and thrown away, and now the ones that I put in everybody's mailbox, they're gone. Somebody took them out of the mailboxes. I had them in every mailbox, they're gone.
Oh,
oh, if somebody ain't putting stuff in my mailbox, that's illegal.
yeah.
That's a federal box.
We're talking about the village trustee mailboxes here on the little stack on the cabinet. I put agendas in there for all of the
Okay,
officials,
let's call the
and
meeting
they're
to
gone.
order. The only thing we'll discuss is bylaws from here on. Meeting's called to order. We'll do roll call. Get the notes in there.
You want me to do roll call? Trust,
Go ahead.
you want me to do it?
Yeah, go ahead.
Trustees Waterman,
Here.
Hinkleman,
Present.
White. Is absent. Shedder, is absent. Gallagher,
Yes.
I'm here. The mayor is absent. The clerk is absent. Treasurer is absent. Is there anyone here that the clerk asked to take minutes of this meeting? Is there anyone here for him in any respect to take care of that matter for today's meeting?
First, you should probably appoint who's gonna run the meeting. That's what I would suggest.
Senior
Well,
trustee.
we've always had the senior trustee do that, so Steve, are you going to be running the meeting?
Well, I think you should, everybody should just vote on who is gonna run the meeting.
I'll nominate Steve Ballard to.
Seconded.
Take a vote.
All in favor?
Aye.
Aye. Opposed?
Appoint a secretary for the meeting, or
Clerk?
a clerk for the meeting.
Temporary appointment
We'll
secretary.
appoint Sherry Croton.
I'll second that.
All in favor?
Aye.
Aye. Opposed? Let's do the pledge of allegiance before we start.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Is there
The agenda is posted outside, and it has one item on it, and that's bylaws.
okay.
The other agendas have disappeared.
You might wanna include that in the minutes.
Our clerk sometimes does a little vandalism, Joe.
Here's, and I had some conversations today with Sherry. My job is to tell you how to follow the laws. And then your job is to do, my job is to tell you whatever the laws are. Your job is to do whatever you feel you're elected to do. So, those are two, those are different things. They sound like we're cutting threads, but it's really not. Because you as elected officials can do lots of things, and can't do lots of things. And, but my job is just to advise you as to what the law is.
Does he have a copy of that?
That's them up there.
There's one in front of your book there. Copy of some bylaws that we were going over.
You want to hand these out to everybody?
I don't know how you wanna do the meeting.
Okay. This is the stuff that Joe printed out, which is rules of order and procedure. To kind of, I guess, kind of gives a template to go by.
This is the same stuff White tried to pull on to us with you a while back, wasn't it?
This is similar to the ones that we've seen before.
This is for later.
Yeah, I don't see that either.
Huh?
I got it.
Okay. There's a couple extras here.
Joe, I guess what we really need the guidelines on is our bylaws. We know we need to get them in place so that, I mean, right now, we haven't seen the checkbook in 3 years, we haven't seen a bill in 3 years, we haven't, we don't know where the money's going, we don't know why,
I discussed a lot of issues with Sherry today. But one of the things that the purpose of our meeting, which is I think kind of what we should stick to today, is what the purpose of our meeting is. And I understand there's other issues that are out there that aren't always related to the bylaws, but they may be integral to them. They may come back around to help that out. You are using the term bylaws, and from my research, I found out that municipalities which are adopted pursuant to Illinois codes have to follow certain federal rules, obviously, and certain state statutes. And so when we think of bylaws, we think of the operating procedure for a corporation maybe. And so I want us to not use the term bylaws, because what I found out for corporations or for municipalities is that they don't really have bylaws. We have what I would call rules of order and procedure is more what it is. And although those are oftentimes included in bylaws, bylaws can include other things too. So what I think, what my advice would be pursuant to my review of the state of Illinois codes is that this is done, this rules of order and procedure are done by establishing an ordinance in the village of how their city meeting should run, which I think is kind of the point of what, as I understood the point of what you were trying to get. And so that's why I sent you this. So it may not deal with directly with all the other issues that are out there, but at least it gives us it gives the village procedure in which to operate its normal village meetings. And its normal village meetings that procedure is done by ordinance. And I might say this, I mentioned it earlier, is that there are certain things that we as a village can and can't do. I mean, if it's a violation of a federal or state statute, we can't vote to do something different than that, because those prevail over us. And so we have certain constraints that we have to operate under. Okay, so there's some things we can do and there's some things we can't do. I'm here to tell you about what is legal. You as trustees can vote to do certain things that may or may not be legal because you're elected officials, and then people can figure out how to object to those issues. But that's kind of not my, I guess, my advice or my issue to you is to tell you what the law says, what the law is, and then you, as a governing body, decide what you want to do related to that information. And so what I have presented based on the information is kind of a summary, I think, of how a meeting should operate, a city council meeting, and who's the presiding officer, the order of business, just the bread and butter of how a meeting operates, and, you know, what visitors are allowed, when visitors are allowed to comment, however you want to see fit. The presiding officer at whatever that meeting is basically in control of that meeting, unless the members decide to take and appeal that decision through a vote of their own. So for instance, if somebody didn't like what you were doing today and you called that person out of order, and the other trustees who are here today wanted to overrule your decision, they would make a motion to appeal your decision as the head person who's running this meeting. And then the vote would be taken, and whatever the vote is the vote is. And that would go on record then to allow that to happen. And if it was to allow additional people to talk, the additional people would be allowed to talk. If it was allowed to take a vote, the vote would be taken. And so that is, so that the meeting would operate,
Even if they're not on the agenda, you couldn't vote. So if it was something not on the agenda, that's a problem we have. If you're not friends with the mayor, you're not getting on the agenda.
yeah, I think I understand you have an agenda problem. And,
I mean, all four of us could call, five of us, Jason's not here, we could all five call him and say, we want this on the agenda, he won't put it on.
yeah, and I'm not here, just so you know, to take sides.
Right, but
Well,
we're trying to get
But
through
the
this.
point is that if I'm understanding you correctly, by establishing rules of procedure, which would include establishment of an agenda, either during the time period before a meeting or at the meeting we're having now, because specifically, we made a motion last month to have specific items on the agenda. Now, there is no agenda here, none of these items are on the agenda. Now, where do we stand? And I'm not saying this in any other fashion than, okay, we've done all these things. We have made motions, we have passed them with a majority vote, and they're still not being taken care of.
Yeah, being taken care of, that's, so, here's what you do. You need to establish a mode of operating your meetings. There's a lot of case law on establishing agendas and new business and old business.
You know, that's the main thing we told him to put on the agenda, he won't put it on.
Yeah, and that's a really interesting issue because from many of the cases that I read, generally it is not liked that there are undisclosed new business, or, old business should be on it because it should be included as part of your past things that you've discussed before. But new business specifically should be pre-disclosed on that agenda so that the public,
No, it's part of the Open Meetings Act.
well, hold on, the public who we're trying to inform about this knows what is gonna be discussed at this meeting, and it's not something that comes up happenstance. And so the codes are trying to require and desire that there not be, contrary to that other comment, not be kind of a new business, old business item on the agenda. But given the situation of not adding things to an agenda is a different issue than adding things on to new or old business. And it may sound like it's cutting hairs, but I don't think that's the case. And so I think that given the situation of predetermined issues that want to be discussed at either committee levels or at council levels, I'll call us a counsel for I'm more familiar using that term. And the exclusion or exclusion of that matter on the agenda, I think that the proper procedure to include that is to provide notice of that item will be discussed as an item on the agenda, just like you're doing with this meeting today. And the proper notice is given so that everybody has the notice so that they know what issues are going to be discussed. Now, if you come to the meeting and that meeting is not on the agenda that's prepared, but is on another agenda that is about matters that are going to be discussed, I think the proper procedural issue would be to bring that issue up, to discuss it, and who's ever presiding at that meeting, the mayor, if not, can choose to have it added or not added to his agenda. And then the proper procedure would be, if he decides to exclude it and not include it, would be to make a motion to appeal the administrative decision of the presider of that meeting. Have a roll call taken, everybody talks about it. What then should happen is that discussion should go on, regardless of whoever's presiding at that meeting, regardless of their opinion. So we're allowing it to happen even though we don't know, there's dissent over whether or not that discussion should happen. So he's been, let's say he's overruled, let's use that as an example. If he's overruled, that discussion should go on. If he's not overruled, that discussion should go on. And it should happen in case later parties independently want to appeal that decision so that they would know what was going to happen, so that it happens, is all I'm getting at, I guess. So it still happens. They shouldn't be able to stop it from happening. It should still happen. It should go on. The vote should happen. Whatever happens, happens. And then whether it's legal or not legal can be another issue that's decided in another day. Does that make sense?
Kind of. What,
Yeah.
let's just go,
Does it?
for instance.
It's it's really a lot of stuff on,
Is the fact that the agenda items were added at the last minute violate the OMA Act at all?
Right, see, that's.
I don't know if, given the base of what the law says now, I'm not so sure I can answer that question. I think it's more of an issue by issue situation. There is, from what I've read, the courts are determining these issues. So when the courts determine things, one court determines this, one court determines that, and sometimes there's still areas that are kind of gray in that. And I think what the courts have, my understanding of what the courts have determined is that they want the public to know what the issue is that is going to be discussed at the meeting. That is how the courts are, not the discussion per se, but they want the public to be informed about what the issues are so they know whether to attend or not. Because if they don't have any care in that issue, then they wouldn't attend. If they do have a concern over that issue, they would attend. And so that's the perspective. It's not how the actual decision comes out related to the issue that's being discussed. It's more of a, familiar statutes is more of a notice issue to the general public, that the public is being apprised of what issues are going to go on at that meeting.
And our issue as trustees is how to get that notice publicly published, so they can see.
Well, you just go about the normal procedures to publish a notice of a meeting.
So that would have, at the same odds I've been at,
Clerk
the trustees are issuing one notice and agenda, the clerk's tearing it down and putting up a different one, or none at all.
Well, those are all different issues, but if you have, my understanding is if you have the proper notice provided for the meeting and what's gonna happen at that meeting, just like today, that meeting can occur and it can happen, and if the proper procedures are followed to make that happen correctly, then it is a valid meeting. And people can fight about that later on, whether or not that was a valid meeting. But at least we have provided the basis of whether the notice was given, whether it's determined, I'm repeating myself now, but whether it's determined to be on the agenda or not on the agenda, would be an issue that may not be determined at that meeting. It would all depend on how that meeting, what happened at it, I can't forecast.
Okay, back to our rules of order and procedures. Look down at that number 7.
Go on that bylaw, please.
How can we, I mean, I know you know what should be, that the board should approve all checks before they're ever wrote. But that's not the way we do things here in Cleveland, for
That's the
some
way we
reason.
used to do things here.
Right, ever since Jim's, it's been about 3 years now that we have not seen a bill. We have not seen, we don't know what they're writing checks for.
Yeah, and that's now we're kind of going into the gray area of what this meeting's not about. This meeting's not about, what people can do as a result of the treasurer following or not following procedures that are prescribed by statute. What we're really here for today is to talk about the bylaws and how to make, bylaws, I'm using the bad word then.
No, I don't think,
Procedures.
I think that's the correct word.
It's not the correct-
Frankly, other municipalities
Well,
have bylaws that govern their corporate authority, and they go by the bylaws.
Yeah, it's more of a procedures and practice that's done by ordinance that council enacts with those
So
ordinances.
we have to put an ordinance in.
So-
Correct.
Right,
Okay.
and that's where I guess I'd like to go with this, to essentially cut to the chase.
Yeah,
What you're saying here is that realistically speaking, if we adopt something like a rules of procedure, like whether it be something like this or something very convoluted like this, that is the way we should be handling things, so that each meeting is prescribed to occur in a certain fashion.
Correct.
So we adopt that by ordinance.
Adopted by ordinance.
Okay.
Bylaws are usually, they're adopted differently, they're usually adopted by a corporate resolution of some sort. And so what the Illinois Municipal Code is saying is that the trustees, the people voted in, are voting, just like any other ordinance, on their procedures and practices for how their council is going to operate. And there's even cases that say that procedures from one council to the next, if they may change,
sure,
that may not be bound by those,
right.
because it's an
Yeah,
ordinance.
And then
and
they would
so
have to make their own ordinance.
They can make their own ordinance about what their procedures are, procedures and practices. And so there's, I didn't read the case, but I read the footnotes to the case that talk about that, because there's a situation where some people wanted to come in and, the old people going out enacted a new ordinance, and the new people coming in deacted it, and they didn't want to be bound by the practices of that old ordinance that required how they operate their business, and the courts found that they were not required to follow that procedure because it was not their procedure, it was the prior council's procedure.
Okay.
However, that
Okay.
may change.
So how do we, so that's what we wanna do then, right? We want to
Yeah.
construct and implement
Well,
ordinance for.
I think that's what this comes down to, is the very things that, whether you read them as bylaws or rules of procedure, or however they're worded here, and I understand what you're saying.
This was just a rough draft that we.
We're just looking at something here to give us a blow by blow. The meeting opens, we do the pledge, we take the roll call, the whatever, all these things are our operating procedures. And in the end, what I believe we're really asking is that, okay, we've got these items on the agenda. Something comes up, somebody from the audience asks a question or whatever. Even though it may not be on the agenda, we still have a discussion on it, if I'm understanding you correctly.
May or may not, depending on what you wanna do.
And
actually, the presiding.
nothing can really be acted on unless it has been posted as an agenda item so that the public is made aware of what's been going on.
You're getting to a little gray area now. You're
No,
you're exactly
Ron-
on the point of what you're thinking about, but, the presider at the meeting, who's ever in charge of the
Sure.
meeting, has the power to allow people to talk or not talk.
Sure. And
that's their choice, whoever they may be. And you can set that by these rules of order that you follow.
okay.
Okay, that would allow visitors to talk, sign in and talk about certain issues.
State their case.
State their case, and you hear it, but the real issue, which you really get to, is, should we make a vote on that issue today, right now, after we've just heard this?
Right.
Now, the presider of that meeting has the authority to allow discussion to ensue on that issue as they deem fit, but may not want to call for a vote on that issue until an official notice of
Sure.
that issue has
Right.
gone out to all the people,
Right.
so that everybody can come to that meeting and discuss what that issue is gonna be about. Because it's kinda like the sneak attack, right? I mean, think about it.
Sure, and-
It's the classic sneak attack.
But you also, it said earlier, let's say the chairman of the meeting does not want to listen to someone, and he says, no, you're not speaking tonight. The board can make a motion and say, no, they will speak.
They wanna appeal the decision of that administration decision that was made at that meeting.
Right.
Yes, they can appeal that decision. And then they appeal that
In order
decision.
for something to have a full effect though, and this is where I guess we've tried to go down a couple different roads with this. But even though something may not be on an agenda item, it does get brought up for a vote. It passes, it fails, whatever the case may be. It gets put on as an agenda item for the next month, which we've talked about having done. And then, because it can be notified, that would be the proper way to handle something.
That would be my recommendation, yes.
All right, and that's where I'm going with something like this, but where my problem lies with this, and this is, I guess, this whole issue again, coming back to rules of procedure, irregardless of how we handle this, what happens if you don't follow it then?
Yeah, and that's a $1 million question. So what happens is this, generally speaking, and I don't know, and I haven't looked in all areas. I have looked in the disclosure of treasurer's information, so I have knowledge of that, which really isn't a procedural issue, and how that is to be resolved. I was asked today to look into that issue as related to minutes of meetings, and what are the remedies of others to, if there is a perceived wrong, right or wrong, to how do they fix it? How do they
Right.
get it fixed? And I haven't looked into that issue yet. And I told you before that I wasn't gonna give you legal opinions on the issues that I hadn't looked into yet. I would surmise, after having looked at, after having looked at the issue related to the treasurer's disclosure requirements through the Freedom of Information Act, and after having looked at some information related to the requirements of the clerk that some type of legal action would have to be brought to remedy that situation and have a court make a determination as to whether or not that procedural issue was correctly or incorrectly accomplished.
Statute's pretty clear on it. And like you're saying, and I follow exactly where you're going with it, and this is the part that bothers me, and hope you don't take any offense, but I'm not interested in emptying the village's coffers, fighting back and forth between you, the state's attorney, the treasurer, the clerk, the trustees, the mayor. This is my problem with this. It's in black and white in the statutes. I can read it, you can read it, they can read it. And I understand what your job is, but I want you to also understand that we're not fools and idiots. We can read the black and white, and if someone doesn't follow what they're supposed to be doing, my question then becomes, is it as simple as make a motion, second, vote, the man's out of office? And that's what you were asked to do. And it's really that simple. And that's the way I see it. And I understand that you don't see it that way, but the statute is very clear.
Well,
He is supposed to have provided information to us, and to date, sir, he has not provided that information to us.
this meeting is about
I understand.
procedures.
And what I have done here is I have stepped into this from the standpoint of a procedure of the governing body of this village. We have the right, as a procedural rule established by state statute. Because, as you said, we can't enact, force, whatever, federal, state, anything different than that. We can be more restrictive, but we can't be less restrictive.
Correct.
And so I say again, by the state statutes, individuals are required to do certain things, whether they be elected or appointed. And my issues, again, come back to, this is a procedural issue.
Yeah, but the remedies that I found relate solely to those positions as individuals rather than trustees. And I think that's what I found related to the Freedom of Information Act. And that's what I found. And so I'm telling you what I found.
Sure, and I'm listening to what you're saying.
I'm telling you what I found, and I am not, the information I found related to that was that the claims, and I didn't spend, I reviewed the ICLE, I reviewed various case law.
Sure.
I didn't look at it, into it for a long time because I understand.
See, I'm not really interested in case law, and I understand what you're saying, because, again, I'm reading the black and white parts of what the statute says.
Correct.
And this is very clear, because all it says is, I can ask him for it, he's supposed to provide it to me.
Correct.
There is no gray area here, and then the problem becomes, now what?
Now, what is your remedy to how to get that information?
Right.
And that, again, is just like we're talking about, whether it be bylaws, procedures, whatever. This is the whole concept behind what the problem here that's going on in this village right now.
Correct. I clearly understand what the issue is. I do. I can't provide you with the answer you may be looking for.
I'm not looking for a answer, I'm looking for the answer.
Well,
And
I'm
it
providing you
really
with the
is that
answer,
simple.
I'm providing you with the answer, but it may not be the answer you want to hear. Here is the answer, is that a single individual requesting that information would have to go to the district court and have a judge, either through a declaratory judgment action or through an injunction, go ahead and make a determination as to whether or not there was a violation of the Freedom of Information Act. It is interesting to me in that individual making that request, the burden switches, and it is the burden on the municipality to prove that they were acting within the confines of the Freedom of Information Act, rather than the other way around, rather than the person bringing the claim having to prove that the village was doing something wrong. So it's a burden switching thing, which is very unusual in the law, by the way. It happens in very few situations. And so, once this claim was made, the village would then have to present to a judge, either through an injunction or through a declaratory judgment action brought by an individual, that this Freedom of Information Act was not followed, and then the village would have to prove to the judge that it was followed, and that if the and then the ultimate question comes in as to, okay, after the end of all this and the judge rules in my favor, then what happens?
Yeah, sure, and that's, and
And-
that's the circle we're chasing here.
I'm not done yet. And so that if there is, the courts have the ability, if there is, what's the word in this? Substantial, no, it's not substantial evidence.
But the bottom line still being, if they're proven to be wrong, the village is still punished, because the village still has to be the ones to pay all the attorney's fees, not the individuals responsible. They're not being held accountable or responsible for their own actions. It's still the village
Correct.
that gets to be accountable
Correct.
and held liable for all expenditures and all.
Correct. And nor am I,
Attorneys.
and now you have to understand that I am your village attorney, right? I'm not here to advise you independently how to provide actions towards individuals in their roles as whatever office they may have. That's not what I'm here to do. That's not my job. I'm here to provide you what the law is, and then you are here to act accordingly to it.
And we kind of know what the law is.
So
What
if
don't
we
know
put
is
these
what-
in the ordinance, we put these in as an ordinance, and next meeting, we vote on. And I'm not saying that it's gonna be every one of these. We make ordinances out of some of these and approve them, then you'll put them in as an ordinance for us.
Correct. Yeah, and they're approved, and you go through the cycle of approving them, and there's a reading of them, and they've been, notice has been published, and it's an agenda item. And if it's not put on the agenda, through the clerk, that additional notice, just so you make sure that it becomes an agenda item, is what, so that the public knows that it's an item to be discussed generally, and that, then the matter does not get put on the agenda, then my opinion is to appeal that decision, administrative decision, to add the item to the agenda. And what should happen is that that item, as I said before, should be discussed, should be voted on, and some type of some type of motion or ordinance should be made, and then the parties, whoever they may be, can fight as to whether or not that was properly done or not after the fact. That's what the case law tells me.
Okay, well,
And the statutes don't really always tell us that much, just so you're aware. The statutes tell us, what it is, and then we need to look further into how the courts have determined in different ways their interpretation of those statutes that are in place.
The Illinois Municipal Code gave us all these lovely statutes of what shall be done, but no remedy for what if when it's not being done.
Correct.
so we can attach a fine to this, like we have on the bottom.
I haven't looked at this yet, and so.
Well, just number 7, there
Yeah,
was,
just read number 7.
there,
There's a
if
different,
they would write a check that's unapproved, there would be a $100 fine.
yeah, when, there's a, and I don't know the answer to that question, I do know this, that when you, as a council, prepare an ordinance that has a penalty clause of finance in it, you have to
Uh-huh.
follow a certain procedure that's different than other ones.
Okay, well, that's gonna have to be, or they're not.
And I don't know, I can't, as I sit here today, I don't know what that is.
So a monetary penalty has to follow a different procedure,
Correct.
has a specific.
Could you
procedure.
find that?
Yes.
and- So that we just do this one time and we're done?
Yes,
Thank you.
I can tell you what that is. Anytime you do that with an ordinance, whether it be, leaf burning or whatever it is, dogs
Right.
walking in public, anytime you, as a city, village, put an ordinance that prescribes a financial penalty for anybody, you have to follow a different procedure than is followed with an ordinance that just does other things
Okay.
like enacting your rules of procedure.
Well, if we don't put the financial on some of these, they're just gonna keep doing it, so.
Well, that's the whole problem that we've got here. It's that because, just like Sherry stated, the statutes are very clear, but nobody does anything about it. And so they're told that they shall or shall not do something, and they do or don't do something. And we're saying, no, you're not really supposed to be able to do that, but hey, they're doing it anyway.
Yeah, I can,
And it's, again, it
I'm
just
not,
astounds me.
I'm,
It truly does,
I'm
because
not
this is
your own
personalities.
independent, I'm not your own independent counsel.
Well, and, okay, and.
Yeah, and on that bill that we just got,
And to that point then, sir, I want to understand, so that you understand, so that we all are on the same page here. We appropriated $3,000 for professional services for the entire year. You realize that this evening's meeting, based on this bill that we just saw at the last board meeting,
it's basically, the
You're done.
clerk and the mayor are using
They-
you for personal gain on a lot of these.
they have apparently discussed numerous items with you, and I'll go to your point of when you sat here and told us what you would and wouldn't do as our legal counsel, everyone would be informed of whatever happened. Mr. Waterman would send a query to you, everyone would be copied or responded in a public fashion. And I would expect the same then, that if the mayor is doing that, that all the rest of us would then also know what is going on, what you're being paid for, besides reviewing something.
If the clerk calls you, Joe, it's gonna be in an ordinance, do not field his calls, because he has no authority.
Our issue with this is
Yeah,
I don't,
our appropriation has been exceeded.
I don't,
And so by
And
state
we
law,
were not
we
brought-
can't
we were not-
pay.
None of us were made aware of this. Not one word was spoke to any of us about all this work being done on behalf of the village through.
There was
through your
never anything
services.
brought up about
We were
this much.
blindsided
Last
with this
meeting,
bill at the
this
last
bill
meeting, that
was
they
snuck
slipped into
into
our
our-
mailboxes and didn't even hand to
Yeah.
us. We had no idea.
You deserve to be paid for what you did, Joe, but I want you to
Absolutely.
Right.
understand that this is a very contentious issue because we are being put on the hook for more than we have ever paid, and it's only in a matter of months. And our appropriations, we've got two choices. Or amend our ordinance. And I don't understand why it is that we're out on the hook for this much money and we haven't even really understood what it is that you're doing for us yet.
Not that we don't
I
understand.
mean, I
We're
understand
unaware.
you're working, but you're working for things that have nothing to do with the village. I mean, Paul Osmond and, has nothing to do with what's going on for the village. The DNR and,
This is the problem.
I understood it as
That
issues
was-
that were involved with
Right.
the village, just so you.
There were
so you're-
issues,
Well, and-
there were issues that were
and that's fine, but-
instigated by our mayor.
yeah. and
You would
they're
have
just-
thought, as the responsible parties for approving expenditures, that we would have been notified that these kind of expenditures were occurring. I understood that your fee was X dollars per hour.
Correct?
Okay, but nobody said that we were gonna expend this kind of
That's not what I'm supposed to do for you. I'm supposed to give you and the mayor who appointed me legal advice regarding legal matters that concern the village of Cleveland. That's
Okay.
my job.
Okay, and,
That's what I think I've done.
well, and,
So
and,
you're
and,
aware.
I
and,
think
Whether or
you-
not-
I think
whether
you
or not-
have.
may very well have.
Whether or not you perceive it as something that was done or there was.
I don't know what you
another
did.
Perception.
We don't know what we've done. We have
We don't know what you
vague
did.
I think
notes.
you're being misled on,
We-
when they're calling you and saying, hey, we got a letter, or you need to send a letter. When you're sending a letter, it's not, you almost have to say, send me a correspondence first, because I don't know why half of these phone calls were even made and these letters were sent, and the village is,
These
you know,
issues
I-
had already been, were resolved,
Yeah.
were being handled internally. And the greater point is, again, none of us in this room were aware that the village had incurred a $3,000 bill at all. We were not aware that the mayor or our clerk were pursuing your services in any way,
Well,
period.
to that
I'll
extreme.
correct you on that. The clerk was not pursuing my services. The mayor was pursuing my services doing, which I understood were issues that concerned the village of Cleveland. And so those are the issues I looked into.
And we don't have the right
What?
to see them issues.
Well,
We don't,
What are those
you
issues?
said that you would take all of our emails, I believe you've got my email, and you would send us, whether one person asked, all of us would receive.
I asked
I have not received anything.
if the mayor.
I don't care if it's the mayor or who it is. If one person asks, all shall
You stated whether
receive.
it was the mayor.
I
or
don't
the
care who
trustee.
it is. One person asks, all should receive.
and this has gone on for a period of time. Not, most of this is undated, but it goes back to December 20.
I don't care if it's about me that they're wanting to check.
I mean, here's
I
one,
still have a
Joe,
right
just
to
for
know.
instance, receive and review email from village clerk with pictures of parking area, $250. Receive and review 2 letters from Mike Erickson.
No, that's, my rate is $250, and there's probably
Okay,
there's a number next to it.
$50, so there's $100 for, looking at pictures that,
I guess the point being is that we were blindsided by this bill, and we're trying to understand, as I believe you understand, we approve the expenditures of the village, the mayor.
We're supposed to.
The mayor may incur these costs, but he has to come to us to approve these expenditures, and when no one lets us know what's going on, other than just handing us a bill, we haven't even been asked yet to approve this.
This was paid before we saw this.
Have you
bill, by the
received a
way.
check from the village of Cleveland already?
Yes.
Yeah.
Before we ever saw this.
Before
This
we ever
is-
saw it.
Prior
is
to us ever
unconscionable.
seeing this, his check was written and
it's not against you, Joe. This is just the
No.
procedure that
And
we've been
please.
dealing with for 3 years.
Please, this is wrong on way too many levels.
You will have to agree with that.
My job is to.
I understand what your job is, but you're not being played fair here, and we're not being played fair. And fair may not come into it at all, but at the bottom end of all of this, my problem with it is that this is a mockery of municipal government.
That's not my determination to make. You want me to make that determination and tell you that that's true or false? That's not what I'm here.
It's not what I'm asking you. I'm stating a fact that if you talk to any other municipality in this area, none of them. I have it on good authority that the city of Silvis, before a check is written, every alderman signs off on it. If our
I
rules
hear
and
you, Kelowna.
procedure will resolve that, I'm all
let's
for
get that
it.
on there right now.
But I'm telling you.
It's going now.
Anything's gonna happen.
But we did that. May of '09, a motion was passed
I know.
by unanimous that no checks be
And
written
so-
outside this boardroom.
But
And
Joe's
no
telling us
Determinations
it's
or
put
not.
into an ordinance, they'll have to do it.
This is
All right?
ridiculous.
So a motion isn't good enough now? A unanimously voted motion?
All right, we can argue all night on
We're
this.
not arguing
I
it,
don't,
trying.
I don't know, that's a good question, I don't know whether what you're saying needs to be done by ordinance or motion. There are actions that can be done by motion and not by ordinance. It would depend on the issue, but I can't tell you from your comments whether or not it requires an ordinance or whether it requires just a vote, affirmative vote of a motion.
Well, for instance, number 7, we voted passed unanimous, and it doesn't happen. So our next step, I guess, is to put it into an ordinance and attach a fine to it. So we've got, you know,
You need to have rules of procedure,
Yes, I follow you completely.
and that's.
I follow you
and
completely.
them rules of procedure need to be put into an ordinance.
Correct, and you're,
Okay.
and just so you're aware, then your issues are gonna become, you can go through and approve these rules of procedure, but if they're not followed, then your question will be, what do I do because this is happening? And I am not the person for you to ask that question to. I am representing the village of Cleveland. I can tell you what's done legally, I can tell you what the law is, and you can vote to do whatever you vote to do,
Right.
or somebody doesn't vote to do.
Right.
I can't tell you how that plays out. It's just, you know, I mean.
Well, I'm already being told that this whole situation comes down to the next election cycle.
There we go.
I mean, I've got it on the authority of several of the state people, and nobody wants to step in this because they believe it to be politics, and I think it's a damn shame.
Okay, motion to adjourn.
Seconded.
It's not personal. I want you to understand that.
I'm not-
It's not personal.
The only personal
I'm
about
telling
it,
you.
that you look back on what
This
you
bill
said.
that you got,
Yeah.
somebody else may be paying that, because I'm telling you what, they
You look
they
back at
can't
what you
expend the
said,
village's
that-
resources and get away with it like
When we
that.
adopted it, you said right then that if one person called, all would hear.
That's wrong.
And that ain't what happened. That's the only thing I
That's not-
have, that's the only thing I have against you, Bill.
That's not what I said.
Yes, it is.
Yeah, it is. I was
Yes,
there
it
too.
is. We're all there.
I said if you wanted to have me discuss legal issues, that I would request that they be put in writing, and when they were put in writing, I would give them out to everyone. I was given matters before that meeting that I was pursuing on behalf of the village of Cleveland. That the
If
mayor.
you
think
do a
you
matter
could've brought
before
that up
that
that
meeting,
night?
and